Alrighty, so this is just with people news one more time. Never look straight forward, always look around you. Be able to protect yourself by any means necessary. Isn't that right, people? Alright, this is one of the ways to do it. The 12 ways that you actually incriminate yourself. Alrighty? Or 12 ways, 19. Okay? And this is Justice Revolution, alright? You guys need to subscribe to them. They go live on a lot of shows. And every one of them I've seen, it's always live, and then they moved it to where we can do what we do. But they don't do videos prior. So it's live and then moved into recording onto what we see today. All right, let's go.
For a warrant, and if the police officer says, I'm not required to ask you for a warrant, you can pull that down and say, well, the Supreme Court says so right here, officer.
Yeah, I mean, we're going to get to that here in some of the rules that we get moving on into, where you're going to see exactly what you need to do.
Yeah, because when you get excited, your brain, all the blood drains, right? And you really can't think well. So.
Oh, yeah, you do. Yeah. I mean, we're going to get to that, which is why it's important that we're covering these. But I love these questions because, yeah, I mean, like I said before, I mean, go back to, go back and review the video of that young man here in Farmington last year who was killed by the police. He was citing Supreme Court stuff left and right. Did they listen? No.
Well, they had an objective before they pulled him over. I
agree. I think there was some serious things there, but again, when you look at things in general, you start citing Supreme Court decisions to law enforcement personnel on the side of the road, they're going to look at you like a deer in the headlights.
But if
my boss says I have to enforce these laws, and I'm enforcing these laws.
But if you're asking, you're trained to do.
Now, my previous video that showed about the attorney, right? He read case law, and they all ignored it. So they're absolutely true about this. But when you do these things, you do have it on record. So the officer has been given notice, which makes him liable now, right? Depends how you do it. You may get them to lose their qualified immunity. You know how judges and officers and all that work, But in general, you gave them notice.
Said, you would say to the officer, do you have a warrant?
Correct.
So if you're going to say that, you have to be able to back it up.
Well, see, and here's the thing. I don't have to back it up to the officer because I back it up on court. Okay. I have the Supreme Court decisions.
Okay.
And that's going to be in my paperwork. Yes, in court.
You're now on camera stating your evidence. That's
correct. Okay. Exactly. This is the scene of the crime, right? We're building the case, right, from the scene of the crime. So go back to what we just talked about. Rule number 5 or 6. It was the foundation of our case starts at the scene of the crime. So this is what we're doing. Okay? So we're going to get to exactly what you need to ask and what the Supreme Court has said you need to ask. Okay? So rule number 9. When in doubt as to what to do next, attack. The best defense is a good offense. Okay? So if you're not having fun, then you're not doing it correctly. We've talked about this. So I've talked to you guys before about, some of the situations I'm dealing with, like with the 3-letter agency that likes to take money from people. I'm demanding my money back. They're ignoring me. So I've heard nothing from them. So should I just do nothing? Well, I can. Or I can go on the offense. I can sue them. I can force their hand in a court of law. And I plan on doing that. So, yes,
this is
Bill.
This is basically the example of what we were just saying.
Yeah, Bill, yes, we would absolutely. We live in a day and an age where we have technology at our fingertips where we can record these interactions. I strongly suggest you do that. Anytime you have an interaction with a government official, whether it's in your local county office, your local municipality, your state offices, or whatever, you're even on the side of the road, pull out your phone. Most of our phones have cameras on them. Start recording. Okay, you have that right. That is a right you can do. That's protected under the First Amendment, and that's been stated by the Supreme Court numerous times. Okay, so again, when you guys feel like your case is stalled and you're not sure what to do, go on the attack. That's That's always going to serve you well. Okay? Rule number 10. In this war, there is no substitute for victory. Right? We talked about rule number 3, I believe it was. We'll accept nothing less than total victory. I think General MacArthur said it best. Do you guys know who General MacArthur was?
Mm-hmm.
You ever hear of him? He was the Allied commander in the Pacific during World War II.
Mm-hmm.
Also did a lot of things during the Korean War. He said this: you're either going to win or you're going to lose. There's no middle ground. You either win or you lose. So if there's no substitute for total victory, then guys, we have got to have that. That's got to be our mindset. That has to be our goal whenever we go into anything we do. We are there to win. And a win may come in a number of different ways. It may come in the prosecution dropping the case. It may come in the judge dismissing your case. It may come in you being convicted, and then you appeal it, and the appellate court overturns your case. And then it may come from when you actually go on offense and sue these people for violating your rights, and you get a fat settlement check. There's any number of different things. Okay? That's what this means. You cannot accept anything less than total victory. There is no substitute for victory. You've got to stay on point there. Okay? All right, now, let's get into some important things to do when you're on the side of the road. So the Supreme Court has stated that there is a rule called, it's what's known as the exclusionary rule. Have either of you guys heard of this rule before?
The exclusionary rule?
Uh-huh.
No. You might have said it, but I can't remember.
So what it is the exclusionary rule is that any evidence that is obtained unlawfully cannot be used by the prosecution against you. So let's say, for example, go back to our situation here. You're driving down the road, 65 and a 40. Cop pulls you over, and you demand what it says right here: to invoke the exclusionary rule, you must demand probable cause, a Fourth Amendment warrant, and counsel be present for questioning. Those are the 3 things the Supreme Court has said you must demand in order for the exclusionary rule to apply. So what happens is you make those demands, the cop ignores you, pulls you out of your car, and starts to search your car, and they happen to find a little baggie of marijuana.
Yeah, that came out of their pocket.
They came out of their pocket or something, right? So now they're not only charging you for speeding, they're also charging you for unlawful possession of a banned substance or something like that, right? If you demanded probable cause, a Fourth Amendment warrant, and counsel, can they use or even charge you with that marijuana?
No.
They can't, because they didn't have probable cause that you were carrying marijuana to begin with.
Right.
Their probable cause was you were speeding, if that's probable cause in and of itself, and I would dare say it's not. I would have that argument. So,
right.
Again, there's that case. Any evidence obtained absent these demands cannot be used against you. Miranda versus Arizona. That's the biggest case that came down in the mid-60s, 1960s. So this goes back to, I think Harrington said this earlier. Let me see if I can find it. I was looking in the chat here. Where Harrington says, ask if this is a custodial stop. Do you have a warrant? Am I free to go? If not, then I will call my lawyer before I answer any questions. Exactly. That's a roundabout way of doing it. But yeah, and again, you have to, these are the things that you need to ask the officer on the side of the road. Because the Supreme Court has said if you're in custody, you have a right to not be questioned without counsel being present. And that's counsel of your choice. I'm not talking about a bar licensed attorney. That's counsel of your choice. Okay? So if you're stopped, you say, Mr. Officer, am I in custody? No, you're not in custody. Okay, am I free to go? No, you're not free to go. Okay, well, then I'm in custody. Even though I may not have handcuffs on me, even though I may still be sitting in my car, if I am not free to leave, then I am in custody according to the Supreme Court. So again, we're going to ask those questions, right? If our public servant,
and just clarify, and I said it over and over, but I want to make sure for even new subscribers, right? Detainment is custody. You're under custodial arrest. Period. So it's always necessary. As soon as that cop comes to your window, he didn't say it, but as soon as that cop comes to your window or any other ways, right, is you to have him directly read your Miranda rights. Okay? Now, that being said, you want to make sure it's on record and verified. Am I free to go? Or have I been detained? And if you've been detained, then you automatically know you're under custodial. Okay? So, you can ask, am I be detained under custodial? Whatever. But you want it clearly on record. And you want to clearly tell them directly, read the Miranda warnings.
Are going to violate our rights, well, by golly, we're going to help them. We're going to help them violate our rights all day, left and right. Because the Supreme Court has stated, again, that we must be belligerent claimants of our rights. What does that word mean to you guys, a belligerent claimant, Erica?
Well, standing firm and strong and claiming your rights. I mean, like when you're belligerent, you're the guy that gets thrown out of the party.
There you go. That's what I'm looking for. Right? Is that what came to your mind, Erica? Belligerent?
Well, I'm a former psychiatric nurse. I worked in an intensive care unit, and that's a common word that we would use to describe situations of a belligerent nature. Yeah, that's definitely the squeakiest wheel in the bunch, to put it mildly.
And I want to add to that, right? So they get on you about being belligerent. Well, the courts tell you you can be belligerent when you stand on your rights. So, between the officer and the courts, that's basically a conflict of interest there. It just depends on which definition you're using, right?
Yep. Yes, Rise of the Republic, custody equals a custodial arrest. Yes. If you are in custody and if you are not free to leave, then you are under a custodial arrest. That's exactly what the Supreme Court has said. So, I like your definition or explanation of belligerent, because you're absolutely right. I mean, you've had people, they're just like, man, this guy is so belligerent, he won't even calm down. That's exactly what we need to be. We must demand that our public servants secure our rights and protect our rights every single step of the way. Isn't that what government is for? Isn't that what we said, that to secure, that to these ends, to secure these rights, government are instituted among the people to protect their rights? Isn't that what we set up this great experiment known as the United States of America?
That's it. It's the only reason, to protect their rights.
Okay.
All right, so we're going to end it here. 13 minutes, trying to keep these things slow or short. All right, these will be the People News. Think about these things. Never look straight forward. Always look around you and always ask questions. They're investigating you as well as you are investigating them. So every time any government officials, always treat it that you're investigating them. Okay? You became a PI. All right, you're a PI investigator. Till next time, y'all. These will be the People News.